We are now going to go to the second substantive session on the theme of Canadian Anglophone African engagements in the human rights and health area. And we have two wonderful presenters. The first will be Professor Ire Iyoha, who's a visiting assistant professor of law and medicine at the University of Alberta. She's going to speak on the topic of reproducing women's health rights, Canadian African human rights engagements, indigeneity, and the spaces beyond the norm cycle. In Igbo, we say ekwe. Apologies to the non-Igbos, sorry. The second speaker will be Mr. Uche Ngwaba, who's a PhD candidate in health law at the Macquarie University in Sydney, Australia, and also a fellow, research fellow at the Nigerian Institute of Advanced Legal Studies. He's going to speak on the topic of Canadian Anglophone African human rights engagements, a critical assessment of the literature on health rights. With no further ado, I'd like to call on Professor Iyoha to lead off the engagement. Professor Iyoha, you have only 15 minutes, please. Only 15 minutes. Do you hear what she said? Typical Nigerian. She says, no way.
Yeah. Okay. So thank you very much for this opportunity. I work generally in the area of health law and policy. And more recently, my work has begun to focus more closely on women's health, broadly speaking, not just reproductive and sexual health. In my discussion on Canadian Anglophone African human rights engagement, I will be focusing on specifically on women's health rights. I am also interested in the concepts of normativity and indigeneity, and how these interact with the reproduction or implementation of human rights in Anglophone Africa. I'm particularly interested in discovering what ways they reveal gaps or limits in the theory of the norm life cycle. So in conducting this inquiry, I will be assessing the nature and origin of norms within the context of Fenimore and Sinking's theory of the norm life cycle. I evaluate the characteristic diversity of norms, especially regarding their impact on human rights, the process of internalization of human rights. This takes some getting used to. I usually have my screen here, so I'm going to have to get used to this. I will examine indigeneity to the extent that I want to compare the cultural traditions, aspirations, and needs of Canada's indigenous populations with those of Anglophone Africa. And as I go through my presentation, the question I would run through, and I hope we bear this in mind, is how is Canada's human rights engagement in Anglophone Africa and in its own indigenous community limited by the empirical diversity of sociocultural norms and the social cultural identity of Canada's indigenous communities. I will explain this further as we go on. I wanted to begin with the norm life cycle, but because of time constraints, I'm going to, skip it, because I'm confident that I am talking to, a group of experts who probably know this theory better than I do. So I will move ahead, jump through the hooks, and begin with women's health rights under international human rights law. Now, generally, the human rights instruments, both internationally and regionally, focus on granting women rights to substantive equality, to life, to liberty and security of the person, and to reproductive and sexual health. Now, women under international human rights law have a general right to enjoy the highest attainable standard of physical and mental health. And regionally, African states are mandated to protect the reproductive rights of women. So Canada's dedication to women's health rights is quite evident in the initiatives that it pursues in Anglophone Africa. And to this end, Canada has the Office of Human Rights, Freedoms and Inclusion. There are three divisions. There are three divisions in that office. We have the Human Rights and Indigenous Affairs Division, we have the Inclusion and Religious Freedom Division, and the division focusing on democracy. Now, this tells us how much importance Canada places on its human rights engagement locally and abroad, and how much importance it places on its commitment to indigenous communities within its enclave. In pursuing its international obligations under human rights law, Canada focuses, on three or four rather different strategies, providing direct support for development of democratic institutions and practices, providing international development assistance, providing legal and administrative training, and providing technical assistance. And the initiatives that Canada has undertaken in the Anglophone region captures these four strategies or approaches. I'm going to focus on the women's health area, and in doing that, I talk about briefly Canada's commitment to UNFPA initiatives on reproductive health care and its commitment to enhancing and protecting adolescent health care and rights in the region. With regards to the first, the institutional funding for UNFPA initiatives on reproductive and sexual health, Canada hopes that its $5 million plus funding will go to making sure there is access to sexual and reproductive health care based on the values of gender equality and human rights. There is an advancement of policies and programs prioritizing adolescent health, furtherance of the rights, the sexual and reproductive health rights of women and girls. And in doing this, Canada, and this is borrowing a phrase from the country, Canada says it must consider population dynamics in supporting reproductive health services and designing policies. I will pay particular attention to population dynamics because of its relevance or centrality to my presentation. So, on advancing adolescent rights, Canada hopes to again strengthen laws and policies and child protection systems, and of course, advance the human rights of girls, adolescents, achieve legal and judicial development in this area. At the core of its work in this area is putting an end to child marriage and delaying parenthood among girls and youths. Now, while Canada as a state carries out its role as a norm-entrepreneur or as a norm leader, we have civil society organizations in Canada doing the same. Now, I cite one example, the Equality Effect Group, that has an international network of human rights advocates who advocate and engage with communities in Anglophone Africa towards the eradication of gender-based violence. Now, they hope to develop an understanding, a better understanding of customary law and women's rights, with the hope, again, focusing on Aboriginals and African women with the hope of furthering, equality rights for these two groups. The same group has initiated a 3 to be Free project in Kenya, Malawi, and Ghana, and hopes to apply litigation, policy reform, and legal education towards changing the status of women, towards furthering gender equality. Now, while evidence of direct large-scale engagement from Anglophone Africa to Canada is limited, I'm still looking, there is evidence of smaller scale engagement from civil society organizations, founded by individuals originally from Anglophone Africa. Now, these individuals advocate for the rights of segments of Canadian society, and in that, they take on the role of norm advocates. We have a number of NPOs or non-profit organizations working on the well-being of children, vulnerable children in Canada, on the eradication of HIV/AIDS through financial contributions to international bodies who work with patients, and empowering girls and women in Canada. 3 of those organizations in Canada are run by Nigerians, Nigerian Canadians in this community. I'm proud to say one of those organizations is mine. Yes, we're asking for funding. So, having stated these engagements as between these two countries, all right, I turn to the impact of this engagement, of these efforts on ground, all right? And from the data, it seems there is limited impact, I'm sorry to say. Now, reproductive and sexual health rights, are yet to be fully realized in the region, in Anglophone Africa. Africa as a whole and Latin America have some of the most restrictive abortion laws in the world. Abortion is criminalized, and access to it is based on an exception to what is otherwise a criminal law regime. Now, data from the World Health Organization tells us that unsafe abortion is responsible for more than 13% of global maternal mortality, and sub-Saharan Africa bears the hugest burden. Violence against women, harmful traditional practices remain a problem, such as female genital cutting and harmful or widowhood practices. What the evidence begins to tell us is that the internalization of a treaty, or the ratification of a treaty by a state, does not necessarily equate to improved human rights outcomes in all countries. To quote a scholar on this point, a notable professor in this part of the world, Eric Posner, he says, understood in the best possible light, human rights impact studies suggest that a small number of treaty provisions may have improved a small number of human rights outcomes in a small number of countries by a small, possibly trivial amount. And in a report by the Parliament of the Republic of South Africa on violence against women, it was stated that the presence of clear and detailed legislation, of course, drafted on the basis of human rights commitments, the presence of such legislation does not result in substantial reduction in the incidences of violence against women. When we look at Aboriginals in Canada, we find a lack of basic necessities, including proper housing and social amenities. Aboriginals, especially women, lack access to great reproductive health services. By that, I mean reproductive health services that are needed, that are critical for their overall health and well-being. Violence against Indigenous women is extremely high. Indigenous women are beaten, sexually assaulted, and killed in large numbers. Now, a closer look at norms, at indigeneity, at difference. Norms around women's health. There is a consensus that women's health generally, or women's health rights generally, are some of the most contentious with respect to their internalization. They are some of the most contentious. There are always value judgment of women's rights, and these have a significant impact on the process of internalizing human rights norms. Of course, as we know, norms involve shared beliefs among group members. It's okay. I'm a little bit distracted by your conversations, if you don't mind. Norms involve shared beliefs among group members, and they reflect standards of right and wrong. Of course, in these, they create group identity. Identity itself ignites a sense of dignity, claims to equality. As a notable scholar in this area has stated, dignity, the very idea of it, is closely related to equality, because through it, people are able to make claims to an equal status of cultures. So, although Fenimore and Sinkink know that new norms never enter a normative vacuum, but that they develop in a highly contexted normative space where they must compete with other norms and perceptions of interest, unfortunately, they pay little attention to the very real, to the very substantive impact of the diversity of norms and the identity they create in the process of this cascade and internalization of norms. I will explain further. They pay insufficient attention, I argue, to the importance, or the impact rather, of a difference between the very content of an emerging norm accepted by state actors. I emphasize that because I'm talking about the acceptance or the ratification of a treaty by a state, the state level, and the difference between that and the substance of norms that are already existing within the state and to which community members subscribe. It is my argument that the differences between the normative content of human rights norms and current cultural norms in a given society is problematic for full compliance with norms, for full internalization of norms at a local level, not at the state level. And my argument is that this problematic difference is manifest at different levels. The resistance encountered, in the enforcement of state and federal legislation that incorporate human rights norms in Anglophone Africa, it is manifest in the ineffectiveness of efforts or initiatives in the healthcare area among indigenous communities, and you find that difference and that ineffectiveness because of the clash between those health policies and cultural expectations and cultural practices. At this point of the analysis, the research question, hopefully for further exploration, is to what extent is the lack of understanding, accommodation, and negotiation with difference, population dynamics, to borrow a word from Canada, and the uniqueness of indigenous social and cultural orders responsible for the absence of true internalization of norms in the Anglophone Africa region, or of health initiatives and policies among indigenous peoples. I ask, in what ways are these factors discounted? In what ways does or do the Finnemore and Sinking's theory not pay attention to these factors? And as I begin to draw closer to the conclusion, I argue that, or I state from the evidence, from practice and theory, that two fundamental deductions on gaps in both the engagement on the field and in theory can be made. And I classify these in two headings: macro versus micro level norm internalization and normative diversity and indigeneity. And very quickly, the argument on the first count, micro versus micro level norm internalization, is that while there is ample evidence, thank you, I will make it, for sure, absolutely, thank you. I argue that while there is ample evidence of, Finnemore and Sinking's theory, ample evidence of the account of norm cascade and internalization of human rights norms at the state level, what I call the macro level, while there is ample evidence of that, there is less evidence of actual internalization, actual compliance, actual obedience, actual birth-based impact at the community or citizen level, the level I call micro level. I argue that the theory therefore falls short of accounting for the real difference between when a state ratifies a treaty or a norm in the interest of legitimation or conformity or esteem, and citizens' rejection of the norm. I argue that this is evidence in the data on violence against women, the data on abortion legislation, the data on practices, cultural practices that continue to operate in the region in spite of legislation on them. To ram the nail into the coffin, I argue that the very need for a norm leader or entrepreneur like Canada to take laps around Anglophone Africa, especially African states that have already ratified and supposedly internalized these norms, I argue that the very need for them to take laps around as norm leaders has much to do with, and indeed is explained by, the failure of internalization at a micro level. And While it seems that there is limited direct engagement from Anglophone Africa to Canada, I want to encourage that we consider indirect points of benefits in terms of Canada's relationship, in terms of Canadian Anglophone African engagement. And the research question here would be, what lessons can Canada transplant into its dealings with indigenous communities in its own territory from the evidence from Anglophone Africa, where there are differences between notions of right and wrong, where there are cultural and group rights, differences between cultural and group rights, and where the needs, of course, limit the impact of human rights intervention. On the final note, what is a takeaway from my conversation this afternoon? One, that Canadian human rights engagements in Anglophone Africa on women's health, whether it is conducted by Canada, the state, or conducted by civil society organizations, these engagements are micro-level efforts that are aimed at full-scale internalization of human rights norms. Point number two, that they can be significantly constrained, that is, the engagements, the efforts, the initiatives can be significantly constrained by the diversity of norms, by the very nature of norms in the target regions, and therefore, those engagements must be conducted with a recognition of population dynamics. And finally, that as Anglophone, African states benefit from Canada's role as a human rights norm leader in the region, Canada too can benefit from applying lessons learned from its operations in the region towards improving its human rights record in terms of providing the necessary healthcare policies and implementing initiatives for the benefit of Aboriginal women and peoples. On my final slide, I have outlined questions for future research. They are also contained in my paper, so I need not repeat them. And I want to say thank you for your time. It's been a pleasure.
Let me start by thanking the organizers for having me all the way from Australia to be a part of this conference. Today, what I try to do is to discuss the literature on Canada's engagements with Anglophone Africa on health rights, and perhaps offer my initial thoughts on how we can develop the research going forward in the area of health rights. And I will start the way we always do when we're discussing the right to health, by trying to put out a very strenuous defense for the right, because there are some who doubt that that is a right that is that should be legitimately recognized in international law. And so we've had a lot of controversy around the question of what the right to health means, what are the contents of the rights, whether the right has any theoretical foundation at all, and so on. And essentially, the basis for this controversy is, the way the right has been defined by the WHO, that it defines health as it's a state of complete physical, mental, and social well-being, and not merely the absence of disease or infirmity. And it has led to the critique that the notion of social well-being being glued to the concept of health makes the WHO, or makes the enduring problem of human happiness one more health or medical problem to be dealt with by health institutions. There are legitimate critiques, of course, of the very broad scope in which health has been conceptualized, and quite rightly. But then it is actually the International Covenant on Economic, Social, and Cultural Rights that provides a slightly acceptable basis for discourse about the right to health. And leading from there, the interpretive work of the Committee on Economic, Social, and Cultural Rights in General Comment 14, where the committee has noted that in all its forms and at all levels, the right to health contains interrelated and essential elements that have to be applied by each state on the basis of prevailing conditions. And these include availability, that is functioning public health and health facilities, goods, services, and programs in sufficient quantity in the state. Accessibility, the ability of everyone without discrimination to access health facilities, goods, and services. Acceptability, health, goods, and services that must respect medical ethics and be culturally appropriate. And then quality, health facilities, goods, and services that are scientifically and medically appropriate and of good quality. So in engaging with the literature on the right to health, what I've tried to do is to thematize my discourse on the basis of these identified thematic areas from General Comment 14. And so I've tried to consider how Canada has engaged with Anglophone Africa in terms of the availability of health goods, the accessibility, the acceptability, and the quality. Now, in the context of the availability of health goods and services, question is, to what extent has Canada contributed, and vice versa, to what extent have Anglophone African countries contributed to Canada's experience or to Anglophone African countries' experience in the availability of health goods and services? Well, you would be inclined to think that it's a sort of a one-way street, that all the help goes to Anglophone African countries by a very beneficent Canadian donor through CEDA, the Department of Finance, and Foreign Affairs and International Trade, and of course, the International Development Research Council. But you'd be wrong. Well, quite clearly, Canada has a lot of interests amongst many Anglophone African countries in terms of supporting products, services, and initiatives that lead to sort of promoting the availability of health goods and services. But then if I have to assess who has gotten the better benefit, I would be inclined to think or to argue that Canada has gotten the better benefit, because you see, Anglophone African countries, Nigeria, South Africa, and many others, have contributed substantially in terms of professionally trained health workers, highly trained health workers. And if you know anything about the training of medical personnel, you know that it takes a lot of resources and time to train a highly qualified medical doctor, for instance. And so what we have is we have a phenomenon, a migration of health personnel, nurses, doctors, from Anglophone African to Canada, populating the health system of Canada and making Canada to have the infrastructure to be able to meet the health needs of the Canadian population. So, in a sense, Anglophone Africa has contributed significantly to the availability of health goods and services in Canada by virtue of this enormous contribution of its manpower. But that is not to discount the contribution that Canada has made in terms of funding projects in Nigeria. For instance, in 2015, Canada was involved in a project where it was funding a project that should lead to the reduction in the rate of maternal, newborn, and child mortality in 15 states in Nigeria. But then whether or not that actually has resulted in that reduction is still a matter for debate, because Nigeria still has one of the highest infant and maternal mortality rates globally. So that's a question to address on a different level. And then we see that not just Nigeria, Zimbabwe, Malawi, and have also benefited from projects that contribute to the reduction in the level of HIV/AIDS and sustained support for addressing the high prevalence of the disease. So like I've said, On the question of the availability of health goods and services, it's not a one-way street. Africa is contributing, Anglophone Africa is contributing significantly to Canada, just the same way that Canada is contributing to projects that are supposed to lead to better health outcomes. But I would think that a stronger contribution is coming from Anglophone Africa. Now, what about the question of the accessibility of health goods? Here, what we have in mind is the extent to which, by virtue of this engagement, health goods have become more accessible. Well, it is in this respect we see Canada's empowerment of projects or initiatives, such as the one on gender equality and empowerment of women between 2010 and 2013, that Canada contributed to in a number of African countries, such as Zimbabwe, Kenya, Ghana, Tanzania, Malawi, and Nigeria. But then again, with the question of accessibility of health goods and services, I will still point to Anglophone Africa's contribution in terms of manpower to Canada to say, look, it is still a substantial benefit for Canada in terms of making health goods and services accessible. Acceptability, the element here we are interested in is to what extent health goods and services are appropriate, culturally appropriate, ethically sound. And the Dutch review here does not confirm much. And of course, this is an area where we need to look further into in terms of mapping out and understanding what is going on in terms of how culturally appropriate some of the interventions that Canada has been offering, or some of the contributions it's been making, how culturally appropriate and ethical it's been. Now, in terms of the quality of health goods and services, again, it's a very hard question to judge from just a literature review. And a lot more needs to be done to sort of develop understanding on that within the context of the framework that has been developed by the Committee on Economic, Social, and Cultural Rights. And of course, keeping in mind the very contested nature of the right to health. But what I want to focus my attention on is the nature, as in the prospects for these projects, what we should be looking at in terms of Canada's engagement with Anglophone Africa. As a health rights scholar, I'm particularly interested in how any discourse on health or on the right to health is focused on institution building, because I believe that the right to health should be driven by states. And so I'm always very suspicious of any international advocacy of global health or championing of health rights, because the only way that health rights can be championed is if the legal positions of states, of African states, is strengthened. And by legal positions, I have in mind what Robert Alexey describes in his constitutional treatise, where he says that, look, the right to something has three cardinal elements. That is, one, the beneficiary of the right; two, the subject matter of the right; and three, the addressee of the right. Who has the responsibility to bring about the fulfillment of the right? And so what you find is that in the international documentation of the right to health, we have a very weak legal position of the right. So it is impossible for us to take international content on the right to health and sort of use it to drive domestic change in a manner that is effective for better health outcomes. And so what I want to see is how this work can help us to understand what specific contributions Canada has made towards driving the legal positions or strengthening the legal positions, in essence, towards building institutions that will allow Anglophone African countries to, on their own, develop a content of the right to health that reflects their specific needs. For instance, in Nigeria, a specific need would be to bring down the high level of maternal mortality, to bring down the high rate of infant mortality, all right? And in Zimbabwe and so many other countries, on the other hand, it might be that their specific need will be to arrest the high prevalence rate of HIV/AIDS. And so the right to health within those spaces will mean different things. And it is for state institutions to design or to impute content to the right that suits the outcome. So essentially, how has Canada, or how can we understand what Canada has done within that context? And then going further, drawing attention to a current advocacy going on in global health. A group of scholars are pushing for a framework convention on global health. Framework convention on global health essentially is influenced by WHO's latest pet project about universal health coverage. Universal health coverage suggests that we should talk about making healthcare accessible to the people who need them at a cost that is affordable to them. And those who are pushing for a framework convention on global health are saying that, look, if we leave universal health coverage on its own, it is likely to go the way of so many other wonderful projects that the WHO has come up with, such as attaining health for all by the year 2000. That's the primary healthcare approach that came to nothing. And so what these scholars are suggesting is that as a global community, we need to come together and have a convention that specifies global responsibility for health, specifies how much each country should contribute to a global health fund that can be used to strengthen the initiatives in resource-constrained nations that are finding it very difficult to attain universal health coverage. So again, that is something I like to see. To what extent can we map out or track how Canada has contributed or how Canada can contribute to such an initiative? So these are my initial thoughts on the literature. And I would leave the conversation open to be taken up later. Thank you.
Thanks for keeping to your time. Always gladdens my heart. All right, so we don't actually have any designated discussants, but all of you then shall be the discussants, right? Hopefully. So let's move straight up to the Q&A. We'll proceed as we did in the morning. We'll take 3 questions and we'll deal with that. We'll move on to the next. We'll remember good thing I turned. First question from Mr. Sky. Is that funny, Zara? Yeah. Huh?
Okay.
Yeah, go ahead.
Okay, a quick one, and also the fact that I have to excuse myself in the next 4 or 5 minutes. Thank you very much to both the very interesting discussion of the issues. Ray particularly interwoven it already into the FIGMA and seekings theory and asking very interesting question. I thought something that I see, and this is more of a comment than a question, I think, for Ray, something I see in both your paper and Uche's submissions is initial finding is with respect to this idea that was expressed earlier today of engagement at a horizontal level and two-way flow in which Canada benefits in the context of the health now, and African countries and different African countries also benefit, which is rather interesting. It takes a different way from how maybe Basil and I use relationship in the context of our panel today. So I find that quite interesting, and I think it will make for something I will look out for eventually in this space. But for Uche, I think this is a question here, maybe more of something to just think of in a different way to express it. I wonder what to make the claim, for example, that Canada has gained more in the relationship. That you repeated that a couple of times, and it would just be a question of where things are. But I'll be interested in if this committee is such a claim. Maybe you were alluding to brain drain in other ways. At other times, it sounded to me like migration or immigration issues, and got mixed in the analysis, and maybe not a clarification issue with respect to that point. But thank you very much, both of you, for interesting engagement.
All right. Another question? Yes, Dr. Gochu. And then Dean Kangara.
Simple question, which is, if you look at the norms on the right to health itself, Canada operates what is called a universal health system, but that does not necessarily mean that the country recognizes the right to health, constitutionally speaking. And you look at most of the countries in Anglophone Africa where this project is going to be implemented. I don't think there is agreement on whether it's a right, constitutionally speaking, or not. So, to what extent is this the fact that the norm itself is contested? To what extent does it affect the analysis, the kind of analysis that you would want to make? And the question is to both Ire and Uche.
Okay. Professor Kangara?
Thank you. Thank you for those two good, wonderful presentations. My comments are for Mr. Gwamba. I noted your discussion about the brain drain and about and your comment or position that Canada could be gaining more than the reverse, that is more, our inclination, what we might think would be the case. So that is interesting, but I also wonder whether that is documented. I also wonder why that is a relevant question. I know it's relevant, but more of an explanation of why. Is it the politics of that are interesting, or what is driving that position? And related to that, I wonder whether you could add to your analysis other issues that may implicate both Canada and African countries. And here is just a short list that I was thinking about as you were talking. First, the question of health tourism. Is there any health tourism happening between Canada and Africa? Second, the question of the sale of bodily organs, such as corneas, maybe even, what else is sold, kidneys, I don't know. It happens more with South, but I don't know if there is any black market that eventually benefits Canadians. The third question is traditional knowledge. Is Canada implicated at all in the expropriation of African traditional health knowledge or medical knowledge? I know certain countries have been, and certain corporations have taken knowledge from Africa, especially in herbal medicine, and patented it, and that knowledge has been lost. Or the destruction of ecosystems that have this knowledge. The other one is research subjects. Have Canadian corporations, I know Pfizer was implicated at some point in Nigeria, have Canadian corporations used African research subjects to develop drugs or other kinds of medical research? You may probably also want to look at emerging laws in African countries and judicial decisions that are talking to these questions, that are speaking to these questions, as that might also be relevant in how Canada and Canadian corporations or NGOs or whoever engage within the African continent.
Excellent. So let's take the first three questions. We could start with Professor Yoha.
This is question was directed to Uche, but he had a comment that I believe he's not here anymore. His first comment for me, I didn't quite get it, but I just made a note to ask him something he said about having a different view of engagement or so. I don't know if that was related to me, but I'll ask him about that later. On immigration issues, I think that was also about Uche's paper. Ukuchukwu, is that your name? Yeah. Okay, your question was regarding, as it affects my work, the right of health, the right to health not being something that is agreed upon, and how does it affect our analysis? And my response to that is that, first of all, discussions around access to reproductive health services have not always engaged that debate around the right to health. And I find that that is probably the situation, because not only is it a given that, this right is fundamental, but also the resources for meeting these human rights mandates at both the international and the regional level, the resources are not always such that even resource-challenged states cannot make, They're usually very basic, for example, access to contraceptives, the stoppage of practices that are injurious to women's health generally, access to abortion services. So, resources for meeting these mandates are usually not such that even, poorer states in the region cannot meet. So I guess that's why we do not always find an engagement with the issue of the right to health. But now that you've mentioned it, I think it's worth also investigating perhaps what role can that play in changing the dynamics of the debate. So thank you for raising that. Most of the other questions by, please, can you kindly remind me? Sylvia. Yeah. Most of the other questions, I think they were directed to Uche. Was there one for me?
Can I make one for you?
Oh. Please don't make one for me.
Okay.
So
we can discuss.
I beg to stop here then, since they weren't directed to me.
Okay, thank you so much for the questions. Okay, the first question says, what empirical basis do I have to support the view that Canada has gained more? Well, in fact, there are studies, I referred to a couple in my paper, that sort of, and these are studies conducted by Canadian scholars that sort of try to see if Canada can develop a policy to address this trend. So it is a problem that is quite widely recognized, that the health system of Canada is being driven by manpower from resource-constrained nations. Why is this important? Is it because of the politics, or is there a political undertone to it? Well, it is very significant if we put it in context. Let's rewind back to the Ebola crisis of 2014. Okay? For some of you who are following the crisis, you would know that some of the countries that were badly affected were so affected because they didn't have an effective, properly staffed health system. Liberia, for instance, in one of those countries, I think they said the ratio of doctors to patient was about 1 to 10,000. All right, that is far beyond the figure that WHO says is appropriate. And to train one doctor takes a lot of money and a lot of time. So if Nigeria or Liberia or Guinea or any of these other countries spend their resources to train doctors, and then all the doctors do is to pack up and go to Canada or any other Western country for that matter to sort of practice, then you see that it is a significant loss to the health system. And the only reason why Nigeria was able to address the disease, to tackle it on time, was because we had a highly sophisticated, a highly experienced medical profession. It was Dr. Adadevo, at the expense of her life, who noticed that this man had something that looked suspicious and held him on quarantine. She said, "You're not going anywhere." He said he was a diplomat. He was going to attend a conference in Calabar. He says, "You're not going anywhere until I confirm." And also because Nigeria has been carrying on Ebola research for a number of years. And so they were able to bring in the experts to come and look at him. And then they were able to confirm, this is Ebola. They first problematized it. This is Ebola. You're not going anywhere. This is a very dangerous disease. And so they locked him up, and that was what saved millions that would have been affected. So do you see how the decision of one person can save lives? Liberia and those other countries, they didn't have that. And even the way Nigeria responded to the disease, Nigeria's response was more effective than even that of the Department for the CDC of the US. Nigeria's response was more effective. Was the WHO commended Nigeria's strategy for dealing with the disease. Public campaign, well-articulated information of how the disease is spread. We didn't have the rumor mongering that was carried on in the US and in so many other countries, Western countries. So,
Go ahead.
Then you'd have to maybe create a bigger picture, because a counter-argument to that would be that it is also documented that Africa is receiving remittances from people who are working in places like Canada. Of course, you'll say money can't replace a doctor
that is a very...
But just to complete your picture, that's a counter-argument,
Yes.
and it's valid.
Valid, and of course, a further counter-argument to be that Canada sends in money to the health system. But then you see, look, again, let me take you back to the Ebola crisis. When the crisis was at its peak, it got to a point where the African country says, we don't need your money, we need doctors. We need people to volunteer to come to this battlefront and work on this. We don't need your money. Because if you pump all the money when it gets to that stage, it doesn't solve the problem. Because what you're talking about people who know what to do, when to do it. So it's a very serious issue. If you say that our health workforce are shifting to Canada and other it's a very big problem, because Nigeria has the largest health workforce on the African continent. Yet, Nigeria doesn't have enough doctors. I can't imagine what is going on in Liberia and these other countries where they barely have the resources to. It's horrible. So if one doctor leaves Liberia, that is 10,000 or 20,000 people not having access to a doctor. Yeah.
May I comment quickly on that?
On this particular issue?
Yes, because I know that BC also commented on the issue of immigration of health workforce. My question is, and I hope Professor Obi would also be able to, say something about it, is whether issues of immigration and sale of organs and, like as you mentioned, Sylvia, whether these are implicated in this research, though, because I think of human rights engagement in the context of this research as involving advocacy and ground-level contributions that are founded on a declaration of rights that are right-based. So because the issue of what health workforce movement from Africa to Canada and other Western nations, I don't know that is done on the basis, of rights, but rather on the basis of economic and personal reasons. So
And it's good you raised that perspective. And this is where health law scholars like myself always have issues when we are advocating for the right to health, because there is a sense in which we always argue that the right to health is a right sui generis. Do not argue the right to health the way you argue other rights, in terms of that it is on paper, and therefore that we can form an NGO for it, all right? We are interested in outcomes, okay? How does the right translate to better health outcomes? We want to follow through the right to the very point where we are seeing a change in indicators that show that the health system is making progress. So, and it is a whole package. It's a bundle of package. It is not just what the books say. It is also the systems, the practices, the laws, the institutions, the framework. And so if Canada is an obstacle to the health system, keeping abreast the challenges of communicable, non-communicable diseases and all of that, then it's a problem. Then it is disemboweling the right within the context of how that right can translate into better health outcomes.
So we can construct it as limitations within Anglophone Africa rather than as contribution to Canada. Not as
If,
engagement
if,
to
if, Canada, if Canada is a direct beneficiary, then we can construct, we have to use right discourse. If Canada, anyway, yeah, so, then, someone else asks that Canada has a universal health system, but does not necessarily recognize the right to health. To what extent is it because the norm is contested, and how does it affect our work? Okay, that's a very good question. Yes, it's true that Canada has a universal health system and may not necessarily have a constitutional right to health. But you see, what is interesting is that the right to health doesn't necessarily have to be part of a constitutional provision. You don't have to have a constitutional provision to say there is now a right to health. You can either have such a provision, or you can have systems and practices that lead to the outcomes that the right to health should guarantee. Why you need a right to health is in a situation where things are incurably bad, and you want to start a sort of an advocacy. You want to give tools to people to advocate for things to change. But Canada has a system that is in place that ensures that its citizens have minimum levels of protection in terms of their health. And so they don't necessarily need a constitutional guarantee, but doesn't mean that they don't have a right to health. The mere fact that they have a health system that claims to be one that pushes for universal health coverage is a clear indication that that is a right to health, because universal health coverage converges with the right to health because they all pursue the same objective. So you don't need to have a constitutional guarantee so long as the outcomes are being experienced. Now, yeah, I have taken note of the contributions you made, Sylvia, about issues of health tourism and organs and traditional knowledge. Like I mentioned, the literature in this area is there's a paucity of documents that we can refer to suggest or to support any claim or any argument about this. So this is an area that obviously would have to inform whatever empirical research we're going to do about this aspect. Thank you.
Okay. I want you to, I'll come to you, on these two issues that have been raised in the discussion so far. The first is on the issue of concepts. I think there's a sort of conflation of the word human right with constitutional right. They're not the same thing, right? Human rights can exist outside constitutions. So, for instance, in Nigeria, we have the African Charter Enforcement Act. There are human rights there, right? And those rights are justiciable. So, when we talk about human rights, we should not conflate it to whether it's present or absent in the Constitution. Of course, it would be helpful if it's present in the Constitution. You can litigate the African Charter version implied in this, actually present in this case of the right to health. Also, and I don't think that the absence, even if you talk about the Constitution, I don't think that that a lack of justiciability equates to a lack of a right. Justiciability simply means that you cannot go to court and enforce it. It does not mean you cannot realize it through other means. So, for example, Chapter 2 of our Constitution contains guarantees of right to health, which you can realize through activism, political activism. That is the way universal health care was realized in Canada. So that litigation or the sort of the arming of a right with a sort of legal force does not constitute it as a right, right? So I think that we have to be clear about the concepts that we're using. So I wanted to comment on that. The second one was on Uche's point, which has attracted a lot of excitement on this issue of Canada contributing in the health rights area to, Nigeria or other African countries contributing to Canada. And there seems to be a lot of resistance to the notion that Nigeria or African countries can contribute to Canada. I'm almost reading a sort of resistance. How is that possible, you know? We must find a way to read it as not happening, right? That seems to be that. It's an obvious contribution. If you're sending, gynecologists and pediatricians and all these people are escaping, it's a contribution. Everybody who's old enough, not let me finish. Everybody who's old enough knows, for example, that Nigerian doctors essentially build the Saudi Arabian medical system. It's a contribution. Now, the only issue that I have, right, with that is whether it's even a form of engagement, whether there was any engagement happening. Just because you make a contribution doesn't mean you did it through a form of engagement. Do you understand? Was it sporadic individuals just doing their thing? Was there an engagement between Canada and Africa, and Anglophone Africa, or Nigeria in that instance? That's the only issue I have, but I have no doubt, personally, that it was a massive contribution. Massive, in any way you cut and dice it, right? But was it a form of human rights engagement between Saudi Arabia and Nigeria, or Canada and Nigeria? That I'm not sure. Please continue to wait. It appears there's an intervention on this point from Professor Demudia. Yeah. It's recording. Yeah, it's just recording.
No, I have two comments for both Iwe and Uche, but the point I was just going to make, my understanding or the resistance isn't that African doctors and nurses are not making contribution. It is the emphasis which Uche laid on it that defines it in terms that it was quite substantial. So I'm just looking at the basic statistics here. That was why I think Olabisi was like, what's the basic empirical data to substantiate that claim? So it isn't that there isn't contribution. It is that, can one then say that in the absence of these doctors, for example, the Canadian medical health facilities would essentially crumble? And I doubt if that is the case, right? But I think the other question, which I think Obi then touches upon a little bit in my mind, is it's to what extent is this a question of migration as opposed to a question of engagement, right? That is, in other words, one could argue like Obi's, as a Nigerian being in Osgood, is contributed to the Canadian education system, right? I am, as a Nigerian being here, I'm contributing to the Canadian education system, right? And these are in some sense an outcome of personal decisions that are not part of any kind of structured engagement, right? So in that sense, there needs to be some, in my mind, there needs to be some kind of conceptual reframing of what constitutes engagement and what doesn't, and how you make a distinction between those parallel kinds of interactions or migration. But very quickly, I think I have two, I guess I can give my two kind of conceptual questions. For me, I think the question you ask, although it's literature review, I'm assuming this is supposed to provide a basis for field research. The first question I have, or the first concern I have, I think that you seem not to have made the distinction between the process of law formulation and the process of implementation. So you say you're interested in the process, you're talking about essentially monitoring and evaluation processes. So input, output, processes, and outcome, right? In my mind, that will require, most of the projects you mentioned are 2013, 2015. So first and foremost, it's quite difficult to engage in any kind of concrete impact assessment at this particular point in time. But secondly, I think it will be quite important for you to kind of, at minimum, rethink the feasibility of the study by either focusing on the processes through which, whether or not those human rights laws are being implemented, and what are the challenges and the opportunity confronting the process of implementation, formulation, vis-a-vis has been distant from a question about the outcome of those laws. Because in the second instance, we are assuming a causal relationship between the law itself and the proposed outcome. And certainly we know there's a significant amount of intervening variable between the law itself and the outcome. So that just a suggestion for you to think about, framing that question. For Iwe, my question is, to what extent is your critique of the norm life cycle theory really one for which the theory wasn't designed for? Right? It's more, my understanding, again, pardon me, this might be my own limited interpretation of it, but my understanding about it is, it talks more around the ways in which ideas essentially emerge, they get cascaded and get internalized. It tells us very little about what then happens after internalization. So your distinction between macro and micro for me becomes, are you critiquing the theory for what it wasn't designed for, or is there more to that? I mean, I guess I'll leave it at that point.
That's the first one. We'll take three. So second question to the patient, Dr. Madad.
Yes, thank you. So this question follows up on what Dr. U was saying, and this is for Uche, because he was talking about implementation. And the reason why I'm asking this is because you kind of base your argument on more of strengthening the legal position of the countries and institution building. And I was wondering that, have you considered approaching this subject from more of an interdisciplinary angle? Because in as much as you're focusing on, building institutions and strengthening the legal position of the countries, have you considered looking at it from a kind of a political economy angle? Because what you're asking for, because as with most economic, social, and cultural rights, the crux of the matter comes to implementation. It's one thing to say that there is this right. It's one thing to advocate for the right. But when the states, and particularly if you're looking at Anglophone African states, if those states don't have the capacity, the willingness, or how much advocacy you do, cannot really translate into implementing that right and seeing the outcomes that you desire to see for the right to health. So I was just thinking maybe you could, and that if you consider this political, this interdisciplinary angle, looking at it from a political economic, approaches, do you think that this would, maybe this question will reframe, the sites of engagement that you're looking at with, with Canada, and maybe that will kind of, reframe the research you're doing.
Okay. One more question before it's Dr. Weir.
Thank you. My question is for you, Prof. Following what you said, yes.
Am I a speaker?
No, you're
Okay.
not. But you had made it. You had made a comment.
Supported.
Based on,
Okay.
yes, following from what Basil's question to Uche. And while it is acknowledged that justiciability doesn't equate to the constitution of a right as an
Into a
existing,
right.
yes, it doesn't equate to that. But does it not affect engagement? If it is non-justiciable, does it not affect engagement? So the question of constitution is separate from what extent that it affects engagement.
Yeah. I'll answer in due course. Let's take the fourth one. Let's take a fourth one because his hand has been, it's almost falling off from being up. Okay.
We initially, from the pilot development project, when we asked NGOs questions about, women's health rights, some of the NGOs back home, of course, evidence has shown that Canada has pumped in billions into sexual reproductive health and rights of women, especially in northern Nigeria. So the question, the concern some of them raised is, why is Canada so interested in their, in their private parts more than, of course, maybe their right to food? Some of these women don't have like food or even infrastructure, like the clinics are dilapidated and the rest of that. I wanted to know if there's a reason, if there's a justification for that focus on, maternal health and rights. And the second one is maybe to Ire. I haven't read the paper in detail, but in looking at the norm life cycle, is there any way that Canada has played a role in promoting, for example, the National Health Act in Nigeria, which is now, an enabling law? And a couple of things, and it's a bit funny because women's health Nigeria was doing fine, even though not very well with like reproductive health and the rest. Canada has improved it. Some research has shown that traditional women in local communities don't support traditional practices anymore for giving birth. They now rely on the Western one, which is not always available. And how has this affected their response to, maternal health? But my initial question is just is the basic one I'm concerned about.
Okay, let's allow the speakers to attend to these 4 questions, and then we'll come back and ask 4 more questions. So keep the questions coming. Go ahead, Ire.
Okay, begin?
Yeah.
Okay. The first question directed to me is from Professor Idemudia. Very good question. I had a brief conversation with Obi on a related subject before I came here. I think a general theory of norms, such as the one proposed by these authors, I think it must account for particularities, that might affect or limit the effect of the theory, okay? In a paper Professor Okafor wrote a few years ago on a related conference. He did indicate that the internalization aspects of the norm life cycle is one that is hoped would not just affect leaders, but the people, right? But, when you read the theory, you get a sense that there was an overall intention that internalization would refer to both the states and the people, But at the same time, even while you get that sense of it, there is no direct attempt to actually, address in a concrete way, and I'm going to point out the limitation of that too, in a concrete way, the problems that can arise in the process of internalization. Now, generally they indicated that, norms that are influential are such that have a universal effect. Even those norms can be determined cross-culturally, yet those norms that have a universal effect can triumph over those local norms. In even talking about that, about the cultural nature of norms, they do recognize that at some level, internalization has to involve both states and people. And yet the way it is treated, that simply, as long as it's universal and it touches certain issues, vulnerable people, violence and all that, it will triumph and it will be okay. I think that is a serious discount of what actually happens at the ground level. And I think that the disregard for what happens at the ground level actually limits the theory. I consider those kind of issues as spaces, as gaps that exist outside the theory, that the theory should have brought into the circle in order for it to make more sense. That is my sense of it. As regards the next question on the ways Canada may have promoted the National Health Act, I have no evidence, but that is not to say there is no effort, but so far, and again, I'm going to note that for further research, I have no evidence of Canada's direct, support for the initiative, but I believe there should be, because I know of certain international organizations that worked actively at the ground level towards the Violence Against Persons Prohibition Act, right, which is more related to what I do in women's health. I do not know for sure if some of those international organizations came from Canada or from the US or from elsewhere, but I do know they were involved. And to that extent, one would expect that it may have been involved in the passing of the National Health Act as well. But in terms of dealing with body of laws that directly affect the kind of research I'm doing, and in women's health, it would be more the VAPP Act that affects what I do rather than the NHA. That's why I didn't take it into much consideration. But thank you for the comment, and I would definitely look further into it.
Okay. Thank you so much for those who have asked questions. Let me quickly just go through them. I agree with Prof. Okafor about his points that we shouldn't confuse constitutional rights with human rights. And quite rightly, I have argued in other spaces that there are other sites where you can push for the right to health. In fact, I've identified 4 key sites: the international context, the constitutional context, policy and legislation, and then, of course, the judicial context. These are all different sites where you can either synergize or operate independently to sort of bring about the actualization of the right to health. And so emphasis is not being placed on necessarily the constitutional recognition of the right. Now, someone asks if the migration of health workers to Canada is a form of engagement, whether it is indeed a form of engagement, or is it just individuals moving to Canada? It would be wrong to assume that in a discourse such as health, you necessarily need states to sit on a round table to say, okay, I'll give you 50 doctors. You give me, so you don't need that sort of round table conversation around health, because even in the context of the international right to health, there is a sense in which everyone recognizes that there are multiple actors. The states, private actors, traditional actors, that all contribute essential aspects to the way the health system shapes out. Even in the context of developed countries like Canada, America, private health actors are very important core actors in the way the health system is able to respond. So to discount the responses or the stimuli that motivates private health actors to act will be to do significant damage to the health system of Anglophone African countries, where the bulk of work that goes on in the health system is being done by private health actors. And so my point here is that Canada and Nigeria don't need to sit down on a round table to agree we're going to contribute doctors to you.
Sorry, it's on this particular point. I don't want to miss. I just want to jump something in. Now, see, I have a personal experience with that. My sister and her husband, they are both medical doctors. Now they are in Canada. They are in Medicine Hat in Alberta. They are in Medicine Hat. Yes, in practicing medicine. 2 medical doctors. Trained in the University of Ibadan, moved to South Africa. Now they are in Canada. Now, the reason why I want you to to understand what we're talking about with engagement and then the difference is that they used to be in South Africa for a long time. And you know that almost 70% of the doctors in South Africa are from Nigeria. At a point in time when Obasanjo was the president, yes, it's the truth. I mean, the last time I was in South Africa, we discussed it. Wow. Oh. We don't know empirical. Oh, okay. So, but you know that at a point in time, what happened with the influx of Nigerian doctors to South Africa, what happened under Obasanjo was at a point in time, because it was easier to get into write the exams. The government of Nigeria engaged with the government on South Africa to make it more restrictive from Nigerian doctors to get, license to practice in South Africa. That is engagement. That's what I'm trying. I'm just trying to look at it from that way. That okay, now these 2 countries sat down, and it's different from. I don't even think Canada has acknowledged, that influx of, and there are many Nigerians, especially moving from South Africa.
There are studies that are, there are ongoing studies that acknowledge that fact. And
Let me I just want to raise the question, or rather, sort of introduce this into the conversation on this specific issue. I'll get to your point. At least for me, as I conceive it, even in the proposal for this conference, I do not conceive of engagement in a state-centric manner. Right? So that is one thing. So in other words, I do not see engagement as limited to official Canadian government conversation with official Nigerian government. Right? However, at the same time, so that's one end. At the same time, I do not see everything then, any kind of sort of movement between Canada and Nigeria as engagement. So the challenge is how to demarcate the border. For example, there are many NGOs who engage in the health sector, engage in the educational sector in different African states. That is engagement. They may even engage with the government of Nigeria. Right? And things. And I think Uche's point is important because in medicine, you have traditional medicine. Maybe traditional Nigerian healers will engage with traditional Canadian healers, for instance. And people are laughing. There are traditional healers in Canada. Yes. So I don't know. I'm just saying. So that's one factor. I don't know if you guys have finished this particular conversation.
Let me just because yes. Okay. Now let me just make this point about this issue. Why it is really at the heart of understanding the engagement between Canada and Nigeria, and why the reluctance to describe it as an engagement is not doing a lot of service to Anglophone African countries. Now, the point I was making earlier on is that health action, there are multiple actors in the health system. And health actors, you see, at that level of professionalism, okay, you go where the money is, or you go where the opportunities are, okay? The health workforce are very mobile set of people because they can go anywhere in the world because their services will always be needed. And so what we sort of suggest should inform the engagement. If Canada, because Canada on paper, Canada contributes significant amounts of funding to different health projects, okay? And so if you go back to my argument about how it is state actors that should devise what the right to health means for them, then what we want to see in the sort of engagement that should be taking place between Canada and Nigeria is an engagement that will lead to the strengthening of the health system, the structures in the health system that would limit the pull factors from Anglophone African countries to Canada. Because so long as those pull factors remain, health workers will continue to migrate. So essentially, my point is that if you ignore the movement of health workers because it is being done by individuals on their own seeking better life, and you categorize Canada's contribution to maternal projects as a contribution and engagement, then you do not recognize the nuances, the underlying factors that sort of are informing these trends. And you make it very difficult for health systems in Anglophone African countries to sustain themselves because they build their health workforce to a highly professional, and Nigerian doctors are well respected globally. They build, even in the US, Concussion, the film that was released recently, is a Nigerian doctor. Yeah.
Sorry. I think you're confusing two things, right? I have a perfect example for
Perfect example, right? Okay. So in my presentation, right, I cited the example of civil society organizations who leaders of which are originally from African countries, right? So imagine these two situations. You have people who have migrated en masse from Anglophone Africa to Canada and other white countries to, practice privately, make money for their own pockets and economically. But you have this young lady who started 10 years ago now, who is a pharmacist by profession. She comes in, she sets up a pharmacy where she practices her trade and makes money. She's a pharmacist in Canada here, in Edmonton. No engagement whatsoever based on the context of this research. She makes money, she puts it in her pocket. She owns a Shoppers Drug Mart. She's Nigerian. But the same lady, 10 years ago, started a nonprofit focusing on using the arts and other forms of artistic creations to raise funds. And these funds, she gathers them and sends them to international organizations, locally and international, that, support HIV/AIDS patients. Most of the income, from what I know, go to local organizations. Now, that's engagement, and she advocates. She has social media accounts through which she advocates for what she does. It's a broad platform. Two examples from the same person. Does that help, perhaps, to clarify the issue of engagement? And I don't know, but it's perfect. You have to call it perfect.
Uche, I think you are saying two things at the same time, right? And I think and I think it's a question of conceptual specification. That is what we're talking about. Now, so if you go back to Gideon's idea about structures and agency, I'm trying to explain this now, right? So think of structures as institution. So in other words, there isn't a doubt that it is a problematic for sub-Saharan African Anglophone countries that loses doctors to the West.
Pardon?
That loses doctors to the West.
Yeah, no, the initial statement. There isn't what?
There isn't a debate that it's a problem,
okay,
right? For the home states that are sending these doctors away, for their healthcare system. In fact, there was a huge debate, at least in the early 2000s in the UK, for example, which was a very big deal, especially South African nurses and Nigerian nurses, right? The question we are saying is, in thinking around engagement, which is the second point you are making, is the response to that problematic can be an engagement. The actual movement of the doctors or all the nurses themselves isn't necessarily an engagement because it is driven more by individual agency.
And so that is the point where I appear to disagree with everyone.
Okay.
Not everyone.
Okay. I have a few supporters. And so my point is that these are two levels of engagement going on. Okay? at the point where doctors, nurses, and health workers from Anglophone African countries shifts to countries, Western countries like Canada, that is engagement. That is engagement because you see, I define the right to health as accessibility, acceptability, quality. So anything that Anglophone Africa does to contribute to that is engagement.
Can I try to convince him?
Okay, try.
Just small.
Try.
Just small.
Try.
Uche is assuming that every single person who is a medical doctor is coming from Nigeria ends up in the health system. It's not true. There are some taxi drivers who are medical doctors. They came here as medical doctors, but they ended up doing taxi driving. What sort? The whole idea of leaving Nigeria to come here is an economic decision.
Look, the point is that you have these people, they are a ready army of professionals. If the health system is saturated,
Oh, wait. Let me exhaust. Go ahead. Yeah. I'll come to. Wait, what?
So in some sense, it seems like we are having different kinds of engagement, different definition of engagement. You seem to be defining engagement as any kind of interaction that involves two sides. So in other words, so long as there is a flow of any kind, it amounts to engagement. The problem with that is this: it loses its analytical value.
in what sense?
In the sense that if you cannot set the parameters and the boundaries to which the conditions upon which your entire thesis is going to be based on, then it becomes very difficult to balance the tension between contextuality and generalization.
So
right?
because in health discourse, that is a very problematic issue, the flow, the migratory flow.
Yes.
Okay? So there are already well set boundaries and there are very well set understandings about how that's pull and push.
Yes, the pull. Okay, let me use your term. The push factor, right? So the push factor, right? And the response to the push factor is an engagement.
That's another level.
Hold on. That's an engagement. But the actual pull itself, you know what? The people moving itself cannot be an engagement for two reasons, right? One, let me quickly put it. One is this: when people move, right? They move for a variety of reasons. And those variety of reasons might be personal, might be whatever it is. And they arrive at a particular site, right? When they arrive at those sites, their relationship with that site might not have any externalities that generates from that. But when you talk about engagement, you're talking about an interlocutors interacting in different ways, which could have positive or negative externalities.
Now let me ask you a question. Let me ask you a question quickly.
Yes.
If private NGOs from Canada should go to Anglophone African countries to do something, would we be ready to recognize that as Canada's engagement?
Do you know the difference? It's an institution. An NGO is not an individual. It's an institution going into Nigeria or South Africa.
They're private.
Hold on. It's private. Don't confuse private with individual.
Wait. So they're private institutions.
Yeah. They're civil society organizations. They're not private.
That is the same way. The medical doctors that leave Anglophone African countries, they are private institutions in the sense
I'm done. Please.
We're not solving. There can be legitimate scholarly disagreement. So in other words,
there is legitimate ones.
Uche can have his view. We can't almost say
Sorry.
But I think that Obed has raised the issue of intention. I think that's the most helpful thing I've heard. I think it's the intention. Was the movement with an intention to engage on the basis of the frame that we're looking at. I think that's the issue. It doesn't matter if he's an institution or an individual. In other words, a billionaire, right, individual goes now to engage with Nigerian government and say, what do you need to produce human rights outcomes, right? That would be engagement. So I think it's more the intention. I think Ube has solved it. I have 3 people who have been waiting patiently who are on my list. Dr. Kwebe, Professor Kangara, and Madam Gabagambi. That's her name. Don't laugh. Yes.
Thank you, Professor Obiora. I too want to join the debate which has spawned off from the papers presented. But before then, let me just make a little comment about Uche's paper. I find problematic the statement that state institutions should stipulate or should impute content to the right to health according to the needs of the state. It seems to me that from the point of view of distributive justice, this will not be a right, this will be policy. In other words, when government begins to allocate, decide to what resources to allocate to X, Y, Z, it is not a matter of right anymore, it's a matter of policy. And I think there is a certain opposition between policy and rights. Let me take the example of the treatment action campaign effort in South Africa, which everybody knows here. Now, that was a case of right trumping policy. Because here was the government who says that this is how we want to allocate our resources. And the court saying no, because there's a right to health, this is how you're going to allocate it because of the right involved. So the idea that governments should, we call it state institutions, should impute the content of the right to health according to its needs would not be right anymore. It would be something else, at least from the point of view of distributive justice. But having said that, let me just make 3 quick comments about the ongoing debate. First of all, I want to join those who say that there is actually a right to healthcare in Canada. And now why do I say this? If you are issued a health card because you are a citizen or because you are a permanent resident, do you have a right to demand health services once you have issued a card? Now, if you have a right to do that, then you have a right to health services. And not just that, the right itself is associated with your citizenship. Yeah. And so that's a right. In fact, it's even a statutory right. So I don't think we should argue over whether this is a different kind of right from a constitutional right to healthcare. It's probably even more effective. Professor Biora has tried to resolve the controversy over engagement by adopting yes, as the consensus. But I was going to use an example, before he made that point, I'm going to use an example of, now what about Nigerian, African, no, not just Nigerian, African soccer players who have had this great impact on the game professional game in Europe. Isn't that really a kind of engagement between Africa and Europe in the sense that we have this impact, but people go individually. Scouts come and pick one person at a time, but it's not government interaction, but there is a significant impact. Until you, I mean, if this was just a matter of drip, maybe 1 doctor a year, 3 doctors in a decade, and so on and so forth, we say, well, it's not really consequential. But this is an avalanche. You know, until you hear about the annual Congress of Nigerian physicians in the Americas and know the people on the roll of that association, then you know how much impact, how many Nigerian physicians are in the Americas. You know, and the number is quite significant. And these are all top of the range physicians as such. Finally, why this is just my last comment on the general debate. Why does it seem that foreigners, Canadians and so on, appear to be more interested in women's private part than other things that engage in? And I think the reason is this, that maternal mortality is very high. Yeah. The reason why Nigeria ranks about 154 in the 2015 UNDP report on gender development. 154, almost at the bottom, is because, and one of the reasons is because of the maternal. Yes, high maternal mortality, one of the highest in the world. And this is from many sources. Because of unsafe abortion, because of inadequate access to maternity care, because of underage marriage, and the fistula and all those other problems that arise. Now, these are all problems that are connected to women, but they result in a common, yes, a common impact, and that is high, very high, unacceptably high for a country such as Nigeria, very high maternal mortality, and that's probably the reason why that is the case. Thank you.
Professor, no. I'll come back to you. Professor Kangara, let me let other voices in. Yeah.
Okay, thank you. I find myself agreeing with him.
With who?
You are calling him Uche.
Oh, he is Uche.
And I don't know why.
Eh?
So let me try and see if I can say why, but I'm not sure. I'm not sure I can explain, but let me try. Okay, so on the question of engagement, it seems to me that it is not about the private will or the will or intention, but it's more the play of two things. Pricing of healthcare, so doctors will go where they can earn more, because those countries have somehow priced healthcare high enough to pay doctors that much. And then on the other hand, the play of decisions that states make. So it comes, for me, I'm persuaded by the argument that it's systemic and it has something to do with the states. Of course, I see the danger in the fact that that reduces all of us to some kind of pawns in a big game that we don't know the rules, we don't know who the owner of the game is, we are just moving here and moving there, and even the doctors are not spared that. So why is it a state issue? For me, we are even talking of Nigerian doctors. Very statist labels. And I'm wondering, what is the problem with, just thinking out loud, what is the problem with a Nigerian doctor saving a Canadian kid? In a perfect world, it shouldn't matter who's providing health services to who. Of course, it's not a perfect world, right? Don't kill me yet. Hold it. But why are we so eager to give these statist labels, right? Then I'm also thinking, just to put a few ideas on the table, hopefully they're coherent. Why isn't Nigeria producing enough doctors for Nigeria and beyond? Do you have like we have in Kenya this thing that under colonial rule, because Africans couldn't, be as good as to be doctors or to be lawyers, there is a cap on how many Africans can enter the professions. Is that an issue? Because, maybe there is something about that, I don't know. What are there unnecessary barriers in the training of doctors in our countries? Can more be trained? We talk of health tourism. Right now, Asia is enjoying the reverse, where people from North America are going to India and other places to get cheaper healthcare. Again, bringing the issue of pricing of healthcare as something that we ought to think about and not get stuck in, are they Nigerian doctors or not, even though that is important. Then also looking more on the pricing side of things, the global IP system tends to take rewards for innovation to Western countries, and that ends up attracting intellectuals from African countries to get those rewards. Is there something to look at there? The West has employment-based healthcare systems which make it possible for insurance companies to pull resources and pay doctors more. Are we doing well in that area or poorly? Now, we are generous, but we are also mean people, because the West also somehow manages to do massive resource mobilization, charities and all that. We are quite content with just the usual village fundraising for a sick child, but we are not mobilizing to build institutions. So before we send all Nigerian doctors back home, maybe we need
I'm
to...
going tomorrow. Okay.
I hope it makes sense.
Yeah. And not finally, but on this list is Lena.
Thank you, Prof. Mine is simple, and it's a silly question maybe. But I just want to learn from experts, were there human rights in Africa? That's my
At
question.
what point? You mean yesterday or?
Not yesterday, before colonialism. Yeah.
Okay. That would take us the whole day.
Maybe
But,
Dr. Foko
like,
can
I'll see
investigate.
whether whether the, yeah. Okay. Wait. You will respond. You be the first, but let Moses throw something in.
Okay.
Where's the? Can you give me?
I take.
Yeah. You will respond, Richard. Don't worry. Fully. Don't worry. You can be here till night. Because dinner is coming here. Yeah. So don't worry. There's time. Dinner is coming here.
I've been redigesting my brother's position, and I think he's tried successfully so to defend his minority view. I think these discussions, actually, in my view, they give us an opportunity to reflect on the concept notes on what do we really mean about engagement. If we address that point, then this particular discussion will be resolved going forward. Because I remember very well, when the concept note landed in my inbox and I opened it, I started bombarding you with emails asking, Prof, but this is a very interesting topic, but it's very broad. So I think this is an opportunity to define within the framework of the project of what do we really mean with this particular engagement. Otherwise, if you revisit the note again, there is no way that it particularly excludes his view. So, okay, that was the point I was driving home. Thank you.
Oh, Jay, sorry, go ahead. Just a short response to what Prof said earlier on. I think from talking about the justification for focusing on maternal rights, healthy rights, or whatever. If you ask, again, if you go on the field to ask women in the north by asking them, what are your human rights needs? I can tell you that most of them are not even mentioning anything about maternal health. Some will just say, give us nice bowls to fetch from the stream, or give us access to, livelihoods. So it's a decision between what Canada feels is priority for these women versus what the women say is priority to them. I don't know if I'm making sense.
You're making a lot of sense.
But those are the living. The women who are still alive.
Yes, because when we talk about maternal mortality.
Yeah, mortality implies.
Research has shown that northern women in Nigeria, for example, I'm sorry to focus on Nigeria, when they lose children, it doesn't take them a long time to get out of it because having children is not really the problem. It's even having too much that is the problem. So relating to what this population dynamics, there's some suspicion that the reason why they are focused on this might not necessarily because they want to protect more people to populate the world. It might be something else, maybe research to see why are these Africans overpopulated, why are they always going to our country. You never can tell. So
you have a point. You have a value.
Justification.
You raise a value.
Okay. Okay, last one before we hear response. Yeah.
I think that I'll also make two quick points just to what's. I think the question he raises. I understand Solomon's response to the numbers, the UN-looking numbers, but it's a central question in development studies around the politics of representation, which is that what is development?
Please use the microphone.
Which is that what is development, right? In other words, who define what constitutes development and what that means in terms of what the solution is. Yeah. Is it the West or is it Africans themselves? Now, if you think the priority should be Africans to define what it is their problem and their solutions to those problems, then certainly it raises a lot of suspicion that all of a sudden the questions around this particular kind of issues become central to what Canada's engagement is with Northern Nigeria. The issue isn't that mortality rates, infant mortality, maternal mortality rate is not a problem. The issue is there are several other problems, like malaria, for example, right? There are several other problems which these individuals themselves think as more of a priority. In other words, whose priority are we engaging with? And what does that mean for how we think about the positioning of ourselves vis-a-vis the global political economy and understanding of what of the consequences of that is? So that's number one. Now, going back, I think just to kind of engage with Moses and a little bit kind of engage with what Solomon was saying. The debate, I think, for me, isn't necessarily that the arrival of Canadian doctors in Canada or the arrival of Nigerian football players isn't an engagement. That isn't the debate. The very fact that you move from one place to one place, at minimum you engage with the location. The question for me is about conceptual specificity. In other words, how do you theorize from a very broad conception of engagement that is meaningful beyond a case of saying anything goes? I think the point is, if you define engagement in such broad terms, it becomes very difficult to find a balance between contextuality and generalization. And therefore, ultimately, what comes out of that is, essentially, we can say anything and it will be true. Right? So the point really is, what is the conceptual frame from which we can say this is what engagement means, and so that when we make comments or we make assertion, we are clear about the assumptions, the hypotheses we make, and of course its implications. Without that conceptual frame and that conceptual clarity, what you get is a series of comments, a series of ideas that you will be unable at the end of the day, when, for example, if you go into the field to do data collection, and define this as engagement. And OB defines it differently in terms of intentionality. I don't think intentionality is key to engagement. Engagement can happen intentionally or unintentionally, right? Which is a different debate. But my point is, there needs to be a clear understanding of what the frame of reference is. And without that frame of reference, you impugn on the concept different meaning. And what then happens is you're unable to make any kind of sophisticated theoretical argument that in and of itself can either yield policy or advanced theory.
Thank you. I agree with you, Professor Demedia. I agree on your points that, and I think it aligns with what Moses has said and what a couple of other people have said about the need to conceptualize what we mean by engagement. And so I think that is a broader issue that will be taken up for the project, because it's something that every other contributor will need to address, deal with. And to that extent, now let me specifically address some of the questions that I didn't go through. Someone asked that whether or not there is a distinction between the process of law formulation and implementation, and whether that can impact on the way the right to health is formulated and implemented. Look, there is indeed such a distinction, indeed, and I would like to say that the right to health is it's filled with so many parts that move in such complex movements that it makes it very difficult sometimes for the analysis to be presented in a way that people can easily appreciate it. And so when we try to advance this right, we try to draw on different straws, okay? We use there's a sense in which people try to appeal to a moral right. There's a moral reason why we should do it this way. There is a sense of duty. So different straws are appealed to. And that is why when that takes place, the right tends to lose traction. Because when you begin to appeal to morality, then you're taking it out of the context of rights, because rights are supposed to be able to inspire duty. And so you're talking about positions, legal positions, okay? When I sit with you on the context of my rights, then there is a corresponding duty that flows from you. And so now, that leads me to the contribution someone made about the point I was making about state institutions defining rights. Maybe I didn't come out very clearly about that point. My point is not that state institutions define rights. When I speak about the state, I do not mean just the institutions of governance. I mean both the institutions of governance and the population. Everyone, essentially.
Population is not the state.
No. When I say the state, and the context in which I was referring to, so that's why I said I didn't come out clearly.
Yeah.
When I was speaking about the state, I'm saying the state in the sense of the domestic system, okay, as opposed to the international context. You see, the right to health is a right that has been conceptualized, defined at the international level, okay? And when you define the right at the international level, they try to cut a broad scope for the right. But Nigeria's right to health needs may not necessarily be the same right to health needs of South Africa. For instance, I know that South Africa has a problem with HIV/AIDS, but doesn't have a problem with maternal mortality in the way that Nigeria has, all right? So the right to health for Nigeria essentially should be a tool that Nigeria should be able to use to address maternal mortality. While for South Africa, it should be a tool for it to be able to use it to address prevalence of HIV/AIDS. So what I try to see, the point I'm trying to make is that when we talk about the right to health, we need to move away from that whole satisfaction with the framing of the right in constitutional documents, in policy documents, and just the formal representation of the right to the right in action. What has it translated into? I'm not interested in knowing whether Canada has a constitutional right to health. So long as people have access to health, then you are satisfying the obligations of the right to health. That's the concept there. And so, in that sense, my emphasis on states, and by states, I use it in a very, very loose form, as opposed to the international context. My emphasis on states defining their needs. Here I have in mind what happened in Brazil in the 1980s, when they pushed, and here, when I say push, I mean domestic social actors, pushed for the recognition of a right to health in the Constitution of Brazil. And from then on, pushed for its entrenchment in policy and the legislative documents. And from there on, pushed for programmatic implementation of the right. So essentially, what I have in mind is a way in which states, actors, and institutions can drive the process, rather than what is going on right now, where global institutions like the WHO and global scholars from the North will come to the South and tell you what you need for your right to health. Okay, which is the point OK was making, rightly or wrongly, but the point is that they come from the North to tell you, we think that you need this, okay? Meanwhile, the real issues might be underlying determinants of health: food, water, clean environments. That will make a lot of difference, for instance, in the Niger Delta. But then the North would only come when it becomes an Ebola outbreak, because that looks good for charity. But it doesn't look good for charity when it comes to arresting the incidents, the things that lead to poor health outcomes. And yet, these are very important aspects for the right to health. Now, someone asked the question, have I considered approaching it from an interdisciplinary angle? Look, there's no way you can talk about the right to health without necessarily implicating an interdisciplinary discourse, because in the first place, rights it's a legal notion. The medical profession doesn't know the concept of rights. Yet you're talking about health, which is a medical concept, okay? So by its very implication, it is interdisciplinary. So you have to talk about because when we make claims about the right to health, we are making significant claims on the economy, budgeting, political economy, and all of that. So when you make these claims about the right to health, you put it down on paper and say, what does this translate into for 2017 budgets?
Sorry, the question I think she was raising is about a methodological question.
Yeah, no.
So that's
Can I just say, can I talk?
Yep.
Okay, so what I was saying is, and I'll go back to my own PhD dissertation, which was on the right to food. And what I did, and what my thesis was with the right to food, and I can apply to the right to health, is that it's good to start with the law, right? Because the law gives you, like you say, you can lay claims. And that's when you talk about the right to health or the right to food. Now, and then I looked at it from a critical legal, studies, that theory, and says that, look, there's a limit to law. Now, if you want to really advance this right, you start by, framing it as a law, but then in terms of, like you said, methodologically, you have to look beyond the law, because the law in itself is restricted in what it can do. So you start with that. So I looked at it like a three-pronged approach. You start with the law, understand the limits of the law, then you move to that in the political economy, and look at the issues, the broader issues in the society or the polity that you are considering. And that's what I'm saying, that all that has to go, not about, before you even get to the part of implementation and then the budgeting. And so you have to look at it even methodologically while you are writing, what you're doing here.
Look, I totally agree with you. I totally agree with you. And as a matter of fact, my thesis on this point, essentially, is that if we conceptualize the right to health as a set of legal positions to universal health coverage, by legal position, I explained the whole concept of legal positions. That is a right that is addressed to specific subject matter that is addressed to a specific addressee. If we conceptualize the right to health as a set of legal positions to universal health coverage, all right, and allow for this right to be to emerge or to gain traction in 4 key sites: the international context, policy and legislation, constitutional, judicial context, and provide a means by which state institutions and, in their absence, domestic social actors can push for the sustenance of these rights as a legal position, then it is possible for universal health coverage to be attained. Then it is also possible for better health outcomes to result. So that is the sense in which I have viewed the right. So when I speak about the right to health, I am not just referring to a document that says we now have the right to health, because we have research that shows that the best description of the right to health is indeed contained in constitutions of third world countries. Yet those countries have the poorest health outcomes. They have the most grievous incidences of poor health outcomes. Yet countries that have no recognition of the right to health, countries like Australia doesn't have domestic rights. Yet the Australian health system is one of the best in the world. Australians have universal health coverage. Okay? So it goes to show that, indeed, the formal recognition of the right does not necessarily translate into the experience of the right, or the outcome or the impact of the right on the daily lives of people. So this is one discourse that you have to see through, not just in terms of what the paper says, but in terms of how it sort of manifests in the outcomes. And so I agree with those who say that the methodology has to look beyond just what has been said on paper. I think that is about, I don't know if I missed anyone, but yeah, I'm happy to have this conversation. It's an ongoing discussion, obviously. Because,
we have time.
Yeah.
Okay. Ms. Susie, finally. Please use the mic. Okay. Where is Dr. Yoha? Okay. You guys are not, you're still on the hook. Questions.
So this is basically directed to you, Ire. I hope I've pronounced your name correctly. When you're talking about good practices, you mentioned Zambia, good practices with regards to abortion, I think. Good practices? Yeah, I think there was a slide on good practices. You mentioned Zambia. No, but I think there was something where I mentioned Zambia and South Africa. So
Yeah, South Africa and
Zambia with regards to good practices. I would like to find out like what you meant by good practices, because in Zambia abortion is still illegal. Yeah, so I just wanted to find out, because if a woman wants to have an abortion, then you need 2 doctors actually to sign that your life is in danger. So yeah, I would like to find.
Thank you so much for that question. And I think it's an important one too. In that context, I mean that I'm comparing countries such as those 2 and a few others against countries where it is absolutely still criminalized. And that to that extent, these 2 countries have attempted to at least create exceptions where women can still gain access to abortion services based on their fulfillment of certain conditions, for their, their health is in danger, the health of the child is in danger. They at least go some extent. And that doesn't make it a good practice though, because it's still the criminal legislation that governs abortion, right? Of course, the hope is that ultimately there will be a broader framework beyond the context of the criminal law where women can gain, legitimate access to abortion when necessary, without having to go through the circuitous route of the criminal law. But in the context of that slide, I was comparing countries that have at least made an attempt to create a level of access, even though it's through the back door of exceptions to the criminal law, as opposed to countries where there is still absolute criminalization. Thank you.
Okay, while you're thinking of more questions, I have 2 of mine for Professor Yoha. So the first one I think it's in relation to a point you made about you not being quite sure why the Canadian government was doing a lot of work on reproductive health.
Oh, no, not me. I'll never
Something
say
like that, to that effect. But the note
Was
I
that
have
you?
here is...
Was that your question? That was his question.
Yeah, no. There was some point you made. Anyway, my point here was that I think your work may profit from some reflection on the connection between the politics here. In other words, the emphasis that Canada began to show on reproductive health rights in Nigeria and other places, at a particular moment in history, was deeply connected to conservative politics in Canada. It wasn't just that all of a sudden Canadians were overwhelmed with concern about reproductive rights in Nigeria. It was connected to Harper's withdrawal from other kinds of, first of all, from Africa, and a shift to Asia and Latin America, and also, secondly, from other kinds of human rights concerns, which he saw as left-leaning and all that. And the move to reproductive rights was an attempt to tamper it. Who can disagree with reducing maternal and child mortality? So it was a kind of one of typical Harper politics, right? I'm doing all these bad things in the human rights area, but I'm going to do to shut up the opposition, essentially. It's not as well-meaning as it may appear. All these nice Canadians coming to help African women. I mean, of course, it may have that effect, but the motivation was deeply political in Canada. If you look at our forthcoming work on the Nigeria study, that was one of the findings. And the other thing is that I think you need to be a bit careful about the way in which you use the word internalization, because it just happens that it is means something different in international law than in Sicking's theory. And a lot of times wasn't quite sure how you were using it, right? So internalization in international law essentially is the domestication of treaties in dualist countries where international law does not have direct application.
Sorry, repeat.
Internalization in international law refers to dualist countries.
Okay.
Countries where they believe that national law and domestic system are two separate legal orders. So you need to transform treaties after the state has signed and ratified. You still need to enact equivalent domestic law. That's what internalization tends to mean. But if you're using it in terms of political theory and Sicking and all that, when they talk about internalization, they are talking about something else completely, so that your reader may confuse the two things.
They're talking of something that is what?
Completely different from the way international lawyers use internalization. Internalization in that sense is much more about a kind of production, a change in the logic of a sense of appropriateness internally in people's minds. That's completely different. And they're somehow connected as well. So, or may not be. So, yeah.
Given the fact that, I guess perhaps it's a difference, but given the fact that she's talking, she was specifically using the Siskin theory around non-lifestyle.
Yeah.
I didn't see that confusion.
Yeah, but she was talking about national law as well, and talking about internalization. And there were senses in which she was talking about seeking, and there were senses in which she was talking about internalization in terms of international law. That's what I meant, right? Because it's my discipline, I could see it immediately. So the point was she's using it in both cases correctly. It's just to be careful, right? So that the reader doesn't think they're the same thing, right? In both senses, she was right. It's just that, the reader may. So you may use a separate term, because sometimes in international law we say transformation, we say incorporation. There are other terms you can use. So to distinguish, so that way it's clear that when you're talking about internalization, you're talking about seeking, right? When you're talking about that international law, treaties being brought home, you can use transformation or incorporation, right?
So that in that way, no one confuses both.
Yeah.
We're still able to understand the concept.
Exactly.
Yeah.
Exactly.
I'm glad you weren't confused by it.
Because I guess because we use normal second theory, for me, that became the lens through which I saw everything else.
Yeah.
So I didn't say, as intentional way, I guess you make that distinction. Because it was the dominant frame, I kind of read
Okay. Thanks, Prof, for both comments. With regards to the first, right, I think that was, please kindly remind me of your name. Okay, that was Okay's question that you,
Yeah, go ahead.
I said thank you for both comments.
Yeah, I heard you.
I benefited.
I heard that
from
part,
both.
up to that
But
part,
okay, that was Okay's question that you addressed the first time. In terms
No,
of
it wasn't Okay's question. It wasn't Okay's question. Okay's question was different.
Oh, okay.
Yeah.
Because I have a comment on my paper where I was going to respond to something. I wrote Okay's question, and I was going to respond to it, and it takes the form of what you've said. So I was not sure that I could raise that point.
Yeah, don't worry, it's okay. The important thing is that you respond.
My question is still outstanding.
Oh, sorry, Dr. Uye.
I asked.
Oh, you asked the question?
Yes.
Oh, to me?
Yes.
Oh, interesting. Okay, yeah, that's true.
You said you were.
Yeah, okay. Does the non-justiciability of a human right negatively affect the engagement regarding it?
I said that while we acknowledge that constitution of it.
Yeah, of a right does not depend on its
Yes.
justiciability.
That
Yes?
but do you not think that the question of justiciability would impact on engagement?
No, I don't actually, because I think that justiciability is only a relevant question when you're trying to use the courts or legal argument to produce human rights change, right? So that's the only context in which justiciability becomes important, right? But if you're not doing that, assuming you are, for example, you're doing the kind of human rights activism I've written about that the labor unions do in Nigeria. You know, sometimes they use the courts. Most times, you know what they do. They don't use the courts. They shut down the country. So they can shut the country down over labor rights.
But the judicial
Right?
forum is
And that's
a means.
it's one means.
It's a means, so therefore
Yeah.
it also becomes it's important in that context because even he acknowledges.
No, yeah, but
judicial
only in that context. But that's a minor context. It's a very minor context.
How am not?
It is minor. If lawyers would think it's very major, but it's not. If you think about the way in which social change is produced throughout history, the law is important, but it's not the major way of producing social change. It's key, it's important, right? But it's not the major way. The labor unions have been more effective than all the NGOs combined. I know that Dr. Gochibu may have problems with that. But he has a conflict of interest on the matter.
Totally disagree.
He's an activist from Sidemutia.
No, I guess for both of the speakers, I'm interested in this question around claims about outcome and impact, and I was just wondering, part of my discussion with Uche, for example, the question I asked about the formulation of the law and implementation of law is one around the feasibility of the study, right? In other words, can you really do all you are claiming you want to do? For how long? Is it 10 years, 20 years, 30 years, or is it like 1 year? So that's the point. I was just wondering whether both of you can speak to that question around. So Yuri, for example, talked about the fact that there's limited impact, right? Uche, on the other hand, spoke to the question around that you're not just interested in the human rights constitutionality around that, but you're also interested in the question around outcome and impact. So I was just wondering whether you guys have at least spent any time in thinking around social science methodology around this question around how one assesses causality in terms of the relationship between the variables and how you hope to do that within the context of your work.
Uche, please go first while I write.
Thank you very much, Prof. You've raised a very important question. So, in the area of health, traditionally what we try to do when we map out or when we try to track outcomes is they are not perfect indicators. Matter of fact, the discourse is still in search of the perfect indicator. You will never really find a perfect indicator. But what we try to do is to use a set of broad, comparable frameworks. For instance, in the context of the MDGs, we tracked some health outcomes in terms of mortality, infant, maternal, access to vaccines, and a couple of other indicators. But what we found is that countries where we have low levels of morbidity and mortality they tend to be countries where some of the broader ideas about what a well-functioning health system should be able to cater to are countries where these things are present, all right? So for instance, in the context of Australia, for instance, within the same space where I was mapping Nigeria, right, witnessing 1,500, 2,000 to 580 maternal deaths per 100,000 live births. In Australia, it was 10, 9, 6, okay? In Brazil, you would see a downward trend. In South Africa, you would see a downward trend, undulating upwards, downwards. So, but then when you use that outcome to go and look at the underlying narrative in terms of what is going on in the health system, how much is the government spending, and health financing, again, is an aspect that is used to track what is going on. Then there's something WHO calls catastrophic health spending. Catastrophic health spending is when you spend more than 40% of your income on health. And so when we track how much of catastrophic health spending is going on, and so what catastrophic health spending is interested in is to look at how much health insurance coverage is available to people so that at the point in which they need health services, they do not need to put their hands into their pockets to pay for those services. Because those are factors that will limit access to health, right? And those are factors that can contribute to high maternal mortality ratio, okay? Because sometimes pregnant women die because they get quacks to treat them, all right? If they have the right, well-trained midwives to do the job that they are supposed to do, that figure will go down significantly. So what we do is we look at it from different prisms. You can't use just one lens because, you see, it's a very complex discourse, quite admittedly, and it's very hard to say we're going to have this framework to track it. So the best you can do is to estimate from outcomes, and there are well-documented frameworks for mapping out outcomes, both within the MDGs that expired and within the SDGs that have taken effect from 2015. For instance, there are 17 goals, and health is one of those goals, universal health coverage. And out of it, there are frameworks or indicators that are being used to map out and to track what is going on. For now, those indicators are very useful, and they can give you a sense of what is going on. In Nigeria, the indicators don't look good. They look very bad. And if you compare it to Brazil, if you compare it to South Africa, and if you compare it to India, you see that Nigeria is worst off. And then if you go back to those health systems and find out what is going on in the terms of the right to health, you see that these are actually countries where they are putting in place measures. They are putting in place, they are addressing it. So although Prof said the judicial context has very minute impact, I think he was speaking.
I didn't say minute.
Okay. Okay. Although you were speaking in a different context, I agreed. But look, in the context of health, the judicial context actually has significant impact. Now, I have developed a taxonomy in my work where I say there are 4 ways the interaction of the courts can impact on health. 1, it can enable the rights. And I have India as an example of a country where the courts have succeeded in enabling the right. India has moved from a position where there is, in 1981 or 82, they had decisions where the court said there is no right to health, to a point now where the right to health is now being randomly cited as a recognized right in the Constitution of India. Yet India hasn't amended its constitution, all right? Yet the right to health has come to that point where even the legislature has agreed that there's such a right, okay? Now, see, we have moved the context away from the international law. International law, we have a different conversation going on there. Okay, we are looking at judicial. You're
trying to marginalize international lawyers.
So, look, you see, the point is, the point I'm making here is that, you see, when you talk about the right to health, you need to talk about it in different sites. If you restrict yourself to one site, you box yourself in, all right? And so I have identified 4 sites. The international context is one site. And when we come to the international context, I will tell you something else about what states should be doing. Constitutional context is a different site. And if you come to that context, I will tell you what states should be doing. Policy and legislative context is a different site. And I will tell you what states should be doing. And in the judicial context, and this is what I'm speaking about right now, in the context of the judicial context, I said there are 4 ways that it can be reproduced. The courts, the interaction of the courts with the right to health can impact the system. One, it can enable the right. And I've given you India as an example. Two, it can amplify the rights. South Africa is an example. And if you look at those TAC decisions, the Broom and all of that, this is where the courts have been able to take this dry right that is just a dry text and given it sort of content and meaning and interpreted how and what this means for the allocation of resources. Three, it can impede the right. Indeed, courts can impede the right. And I have Brazil as an example. In Brazil, where you have a legal system that allows for injunctions to be taken out against the state to demand for expensive medical treatment, you now have a situation where it is the elites who have access to lawyers who are now being able to corner for themselves an unfair share of healthcare spending. For instance, in Brazil, you have stats showing that over 80 billion Brazilian I don't know, real or so, which translates to about 4 billion or so American US dollars, was spent in paying off claims, litigation on the right to health. This is money that could have been distributed more equitably in the health system to provide access. Because you see, Brazil is one of the most inequitable countries in the world in terms of you have extreme poverty and lavish as an extravagance. All right. So essentially, it is clear that health equity is a big issue there. And so you see that is a sense in which the court is impeding the right to health. And so because when I talk about the right to health in this context, I am not just interested in whether or not you can go to court and vindicate the right. No, I'm interested in outcomes. How does it promote health equity? How does it lead to better health outcomes?
You have a point, and I think I get it, and I totally get it. My challenge with you is that your distinctions are too rigid. You are about to say you are about to say courts don't care about outcomes, or when you talk about rights and going to court, that's not about an outcome.
Okay, so that's the.
So it's, I'm getting you, except for the.
So that's the point. So you have a very valid point, but let me, because of the context in which I'm speaking, I'm not giving you a broad context of everything. Now, when I speak about how courts engage, all right, here we're saying that sometimes litigation may not necessarily be the best way to. Litigation is useful. It brings people to the table, but perhaps litigation needs to engage in other modes of decision making so that the necessarily adversarial process which we're used to may not be necessarily the best. All right? It's when you bring it to the point where you come to court, the court needs to bring in the policymakers, bring in the people who will bring the funds, and sit down and say, okay, how much do we have? How can we resolve it? It's not about win or lose. It's about. So look. What we are saying, the point where we are pushing to is that the litigation of the right to health shouldn't be just about win or lose, okay? It should be about changing policy in a way that issue that led to the litigation does not happen again.
The problem is, though, it's not with the rights, because you can define rights in a manner that captures what you're talking about. So it's not that we pack the rights here and do something else.
So the point is that we engage with the rights. The rights is just a vehicle or a bridge, okay? It's not the outcome. Simply because we have the right to health doesn't mean we have reached our destination. No, our destination is better health outcomes. So if you continue to look at the right to health as your destination, that's where it's going to be problematic. The right to health is only useful if it can lead you to better health outcomes. If it can't lead you to better health outcomes, then you don't have the right to health. That's the point. And so.
Then you don't have it?
Yes. If you only have
you don't have it or you're not enjoying it.
If you only have a constitutional document or a paper, that says you have the right to health, it doesn't mean anything. For instance, if I give you your citizen's card with the health insurance, that is licensed to walk to any hospital and get treatment. Then you have the right to health. But if I give you a citizen's card in Nigeria that doesn't allow you to go anywhere to receive health treatment, then that card is a useless piece of paper. Even if it says you have the right to health, you don't have the right to health.
No, you have the right, but you're not enjoying it.
So that is the point.
Those are two different things. Yeah. Yeah. Yeah, you don't have it. Yeah. So you're not enjoying it. Yeah.
So the point is that we the point is that we are trying to move the understanding, the sense in which we understand the right to health, merely from, because you see, it is that interpretation, okay, of restricting the right to health to simply what is on paper. It is that interpretation that has hamstrung us, all right? So we want to get to the point where we understand the right has a set of legal positions, all right? How does having this paper empower me, okay, as opposed to not having the paper? That is the sense in which we are engaging with the right to health, not just as a sense of a document that says you can go to court or something. It's what does it result in for you? So then, now, having made that point, so, and finally, the courts engaging with the right to health can be ambivalent towards the right. These are the four words they can impact. And have Nigeria as an example. How is the court in Nigeria ambivalent towards the right? Professor Okafos made the point that, look, you don't need a constitutional document to guarantee, to have a specified right for you to say you have the right. Indeed, Nigeria has domesticated the African Charter on Human Rights. The African Charter contains Article 16, especially says there is a right to health. And it is a direct reproduction of the Article 12 provision in the International Covenant, which Nigeria hasn't domesticated. So it means that even without the domestication of the International Covenant, we already have the International Covenant as part of Nigerian law. That's a different issue altogether. The point is, yes, I'll come to that. The point is that, look, the fact that this right is in the domestic system of Nigeria, you would expect that citizens can rush to the court and secure for themselves the right to health. But no, that is not what is happening. Because what is happening is that the court is speaking from the two corners of his mouth, all right? In one case, it says, yes, you have the right to, yes, Article this has been domesticated into Nigerian law, therefore it applies into domestic law. But then in another corner, it says, but it does not rise above the Constitution. It ranks below the Constitution. And what does that mean? It means that if the Constitution says socioeconomic rights are not justiciable, okay, and therefore the Constitution having superintendence over our domestic law, it means that it says that the charter rights stand on their own leg, but it doesn't rise above the Constitution. And it does not impact on other norms. So the Constitution will continue to impact on other norms, and the charter right, which recognizes the right to health, will still stand on its own leg. It's a contradictory position, really. You have to make up your mind.
No, not necessarily.
It is ambivalent, because if you, as a right claimant, take the charter right to go to court to say, look, I have a right to health under this charter, the Constitution will say, but the Constitution, Section 2, says the right to health is not justiciable. Okay?
That's not what he says.
That is the sense in which, the point is that...
No, that's the prevalent understanding, but that's not what it says. The courts have clarified it. It's not what it says.
The point I'm making... The point I'm making is, I contrast it, for instance, with the position of India, where they were able to use Chapter 4 rights to sort of interpret chapter. That is not what the Nigerian courts are doing. That's the point I'm making here. The courts are refusing to take a stand.
But that is a choice.
That's the point. That's the ambivalence. So that's what I'm saying.
So you're saying the rights are influenced by politics or by context or by judicial...
I'm saying that sort of impact, it's a taxonomy, essentially. It's just to help you to understand sort of the consequences that can occur from the engagement of the courts. They can do one of those four things. They can enable, amplify, impede, or be ambivalent towards the right.
Okay.
So just understanding it and then deciding what is the best way to approach the right. It gives you the basis to go forward.
All right. On this one, I think you have made a very extensive defense of your position, which is extremely welcome.
Can I respond to,
Eh?
can I respond to Gabagame's question?
Okay. You want to respond as a speaker?
No, she asked the question, and it was.
Okay.
It does not
well, that question is rather offside.
Yeah, I just want to point her somewhere.
Eh? Okay.
Because there is a chapter that I wrote for a book called African Legal Theory and Contemporary Problems. It was published in 2012. And the title of my contribution was African Human Rights Philosophy and Chinua Achebe's Things Fall Apart. So what I did was to use the story of Things Fall Apart to illustrate that Africans actually practiced human rights. They didn't call it human rights. But they had practices that, at least in respect with regard to the right to life, fairness in the administration of justice, and there was another right. But what the difference is a huge debate. So the distinction I try to make is between human rights as concept and human rights as practice. So Africans had human rights as practice. They didn't necessarily have it as concept. So that's where you kind of, if you can look at, if I have your...
That's a dangerous...
You mean?
No, I think I know what he's saying, though. I know what he's saying. That is
No,
that
the
particular
articulation, they
in that
didn't-
form, right?
Yes,
Yeah.
they didn't call it human rights.
Yeah, but that's a
But
concept.
they practiced it.
But they had a concept, though,
Yes.
of what they practiced. I think that's the resistance you'll get. They had a conception
Yeah,
of what they
but
practiced.
they didn't call it human rights.
No,
That
it wasn't
concept was
conceived in
not
those
human
in
rights,
bigger
yes.
liberal terms.
Yes.
Yeah. Yeah. Mm-hmm.
Yes, yeah.
Okay. Yes, there's Dr. Kwebe. Please intervene. Dina is on his way, please. Just in case you're wondering. Oh, please, where's the phone? The recorder? Not the phone, please. Thank you.
Thank you. I think that responding to Uchi, that is, I think that the whole notion of judicially enforceable rights is probably overrated. You know, in 1991, an American, Gerald Rosenberg, wrote a book called The Hollow Hope, and he analyzed this great civil rights revolution from the Warren Court to the beginning of the Rehnquist Court. And he concluded that if you look carefully, it is not the Supreme Court case judgments that created this great revolution, but that other factors were at work at the same time, and that the cases themselves may have not been as significant as you would expect in terms of their impact in the evolution of these developments in the United States. I mean, that's a little bit controversial, but I find it a little interesting that the Indian Supreme Court, applying this generic provision, or what has become generic provision, Article 21 of the Indian Constitution, actually ensures that 1.2 billion people have a right to health care by judicial pronouncement. I think that is a little bit far-fetched. I mean, the image of India I have to this hour is a country where many people do not have access to adequate health care at all. I mean, believe me, they have very great hospitals, and Nigerians go all the time to India because of affordable health care. But I mean, not all Indians can use these hospitals really. You know, no, and so we're a little bit careful when we want to reduce the right to health care simply as a matter of right duty. I don't think it really works that simply in practice. It's true enough. South Africa has shown a kind of very important example. But even in the case of South Africa, the way that academicians have analyzed the right to health care, it is not a simple matter of right duty as such. And in any case, the experience of the South African judicial system is not what you find everywhere in Africa. You know, in Nigeria, for example, court judgments are regularly disregarded. I mean, they're just ignored. I mean, even the ECOWAS court that is supposed to be supranational, the government ignores the decisions. So I don't know how you can go to the High Court and say, okay, you have a right to treatment for this kidney disease, and you expect that you're going to get that enforced. You'll be dead before we even hear about the decision is at all. So I think that we have to go back to begin to look at the right to health care, not as a matter, as we see some other kinds of rights, but a matter of the state having a responsibility to provide access. And by access, I also mean affordable access. And therefore, that right will be taken up not just simply at the legal level of right claims, but also at the political level. And that people become entitled to it So the speaker, which says that Australia doesn't have, and use a very strong, doesn't have rights at all, or something of that type. You know, but I think what you mean is that they don't have in the constitution. That's what I said. Yeah, they have in the constitution, but they have rights in through other medium, like statutory and the rest of them. Yes, I agree with you.
They don't have it in statutory documents, as a matter of fact, but they have it in action. We're all saying the same thing. They don't have it in the constitution, they don't have it in the legislation, but they have it in action.
So what is the base of the action?
They don't have a Bill of Rights. They don't have a
No, I agree. No, I'm not even talking about a Bill of Rights, whether statutory or constitutional.
Even in policy, they don't have.
Yeah, but when they implement the right, implement access to health care.
They have a health code. They have all of these things that allow guarantee universal health coverage.
Yes, that guarantee becomes.
The point is that even if they don't conceptualize it in the context of rights, it is still right in action. That's the point I was making.
It is even right in practice as well.
Yeah, so that's what I was saying.
You know, and I think that should be the focus. Enabling us to have access, rather than to just say, when we are able to have rights that are declared as a matter of right duty relations, that will just solve it. I agree that this is what lawyers are used to. You know, that if you have a right, you have a duty that you can enforce. But in this area, I think we have to do better than that if we are to go beyond rhetoric.
Those are exactly my points.
I think we can agree on that. However, I think we shouldn't forget there is a historical context of denial of social and economic rights as
even human rights.
Socialist, communists, which were really, just arguments to prevent Africans from getting justice. So there is a political context that we have to acknowledge that for the longest time, Western powers only cared about political rights, and the reason we are insisting that rights be written in constitutions is because that's the only way you go after Pfizer and say that big pharma, you have violated certain rights. We may not all get the benefit, but at least it's a better situation than before.
I totally agree with everyone's position, especially your point, and that is exactly what I was saying, that essentially it's not about the document. And if you listen carefully to what I said we must move from that point where we're talking about just what is in the document to the point in which it is impacting on outcome. And so that was the sense in which I was speaking.
And he agrees with you.
Yeah.
But what I was going to say is that when it depends also, you have to look at the context. If you're in a state or in a country where there is no, as in not even in practice or in document, you must necessarily have to proceed.
Yes, start with
the document, because that document gives
practice,
you know, the platform upon which to place demands.
Yes, it enables them domestic social actors to sort of, I agree with you. So that's the point, yes.
So also it depends on in the context of Australia, they might not even.
They don't need it because no, the thing about Australia is that they had this fight in the 1970s. Domestic social actors had this fight in the 1970s and secured a right to health in the system. So it's not like it just came out of the vacuum. Somebody fought for it, all right? And so, but then where you don't have the sort of movement already picking up, you need documents to give people the idea that they can pick it up. And then let me just quickly add something about the point you made about India. Maybe you misconstrued the point I was making. My point isn't that simply because people go to court and secure judgment that means the right to health is present. Neither is it my point. Neither do I necessarily agree with your point that a court decision cannot guarantee 1.2 billion people the right to health. What you have to understand about the Indian context is that the Indian context, India has successfully done quite a lot. And when you speak about India, you have to remember that there are 1.something billion people. And so there are issues, the political economy of resources needed to bring about the kind of visible impact that is required. It's much more than what would be required in Brazil or Canada or the United States, all right? So India is a work in progress, but, again, another shortcoming for India is that the lack of constitutional guarantee of the right to health has hindered the promulgation of policy, promulgation of law that sort of specifies what the state can do. And by the state, I mean the federal government. So, because it's an action that has to be done at the state level. It is not because there have been no action at the national level to get about a health law. As a matter of fact, India's National Health Policy 2015 laments that because of the current constitutional scheme where health is a matter for the states, the only thing the federal government can do at best is to put out a model law and try and advise the states to adopt that model law. So you see how constitutional non-specification impacts on even the good intentions to provide for the right. So in a sense, my point is that all of these levers, if you listen to the point I was making, like I said, there are several levers that have to sort of move in a very synchronized way to bring those outcomes. So it's neither just documents, constitution, or courts, or policy, or international. There has to be all of them, but working with a concert. All right? We say, okay, this is where we are going to. How can we, at this stage, contribute to that destination? At this other stage, contribute to that destination? All of them working in synchrony. Okay. We can achieve what we are looking for.
Thank you for that. Thank you for that extensive defense. We'll soon, the dinner will soon be here. This is not necessarily for a huge debate, but I I've been reflecting on the issue of defining what we mean by engagements. My initial thoughts is I don't necessarily want to define that term for everybody, but I'm not averse to hearing your views on it. There are two possibilities. One possibility is you define it the way you want to do for your own papers. But of course, the entire project has to be coherent, so it may make sense also to define it in a lead introductory piece, right? For everybody. What are your views on it? Just 10 minutes and we stretch our legs and then food will come. Yes, prepare and then
You may not necessarily define this is what engagement should be, but you could give some parameters as to.
Start again.
Okay, so I said you may not necessarily define engagement for the researchers, but you could say at a minimum this is what you would expect. Whatever, as in, so give the writers or the researchers that leeway, that's leeway to be able to define, because one of the things I can hear from what Uche has been saying is that for him, engagement, when he defined, the right to health, and you were talking about access and all that, and all that could mean to him engagement. So I think we should, give some freedom to the writers as to what they want engagement to be. But perhaps, maybe if you cannot give guidelines, at least give guidelines as to what it is not. Because if we just leave it as a free-for-all, then just put it in, I don't know, some kind of framework like, okay, not saying this is what engagement is, but these are the attributes, or these are the attributes that could, be seen or should be in your definition of what your engagement should be, or this is what you would not want to, this is too broad to be called engagement. Just some parameters.
All right. Yes, Dr.
I would say define engagement, then allow some subsidiary right for Uche to disagree with that definition.
I want to.
Okay.
Dr.
Weir and Uche. Yes.
Okay.
No, I would say to define it, and then should any of the writers feel that there's a need to disagree, to enlarge or to diminish the scope, then they would have to make the justification for it. But pretty much, if you set out what it means, then that should guide the work again for coherence.
Okay.
My contribution is I think that there is rather than defining, because you see the problem with definitions is that it sets a straitjacket. It might end up not giving us a robust lens to look at it.
That was the idea. You were saying to keep you in check.
Yeah, so I'm leaning towards I'm leaning towards a person's position that you set out a framework that, okay, for instance, universal health coverage, a very broad concept. It has been reduced to 3 points. Okay. It's not a definition, but it's just we're looking for this element. So it can now provide justification to say we were not looking for this element. So even if you think that is an engagement, that is not how we that is not what we set out to look for. So just setting out that sort of point, instead of just defining it, that engagement means this and that, I find that it might be a bit limited, especially since in the lens of health, I will be looking at, I will take engagement further down than just mere exchanges or mere conversations, but sort of like how it has followed through to outcomes. That is the sense in which health is usually being pursued in the international discourse. And to pursue the right to health in any other sense will be not in line with the discourse.
Any other comments? Yes, Dr. Kwebu.
I don't have a suggestion as to how you define it, but I think what you should watch when you write the introductory piece is this element of the official element, whether by official element on one side of the game. How important is it for this transaction to be called an engagement? I think that's what you need to clarify. I think that's where the problem has been during our discussion today. So you need to clarify that whether you want to moderate that and losing the term official to such a level that it may accommodate things that are not state-related in terms of the transaction.
I've already included that.
Yes.
I've already included that.
That's my only suggestion. Thank you.
All right. Any other comment? Especially from those who have never spoken today. Yes, Dr. Bunolo. And even those at the back.
Yes, I agree with those who are suggesting that, well, I assume that it was not problematic when I dealt with engagement. It means I conceptualize it in the manner that I conceptualized it. But since now it's turning out that we understand it very differently. So perhaps the parameters are necessary for us to be able to, for example, to address even the issue of impact, whether we are going to leave impact outside of our assessment of the literature. Because sometimes you'd want to be tempted to ask the question, what benefit was this engagement, to the extent that you are able to come to the conclusion whether really it benefited Canada or it benefited Botswana. So I think to that extent, it's necessary for us to demarcate exactly and to agree. Well, maybe not agree, but to have some form of framework.
Anybody who doesn't agree will be tossed out of the volume. After all, we are living in Africa.
I basically agree with the majority view, but we should also not limit ourselves, because I think as lawyers, we tend to think within the law. So what are the limits of the law? So maybe Uche is taking it from the public health point of view. I don't know. So
he's a lawyer too.
He is a lawyer, but he may also, yes. So yes, I mean, as much as definitions are important, and they are important for us lawyers, but we should also maybe be open to other views. It's just a thought, but I don't know.
Definitely. I was just joking about tossing.
No. Yeah.
Okay. Any other views? We have people at the back benches. And they're not even smiling, they're frowning. Your frowns won't dissuade me from calling you. Yeah. No, the issue I raised was in terms of the actual, I'm thinking of the deliverable, the volume. How rigid should the introductory piece, paper, or whatever, chapter be or article be, in terms of saying, in this volume, this is what engagement means, right? Because there has to be a frame. It must have a coherent conceptual apparatus, right? So how rigid should it be? And so people are kind of expressing views around that. Should we define it? Should we just give broad parameters of what we mean? Allow some individuals to even go outside that frame and disagree. Should we toss them out? I was joking a little bit about that. If they do, yeah, that was what.
My experience we're trying to do a book, a coordinated book with a colleague from the UK, and a couple of other books that I have also seen. I think for questions around to allow the chapters speak to each other, there needs to be some degree of rigidity, but not rigidity in the sense that it excludes possibility for innovation. So in some sense, it might sound like contradiction. So on one hand, you're saying let's be rigid. On the other hand, you're saying, well, let's not be too rigid, right? Yeah. But I think, given the conversation that we've had, I think clarifying at minimum what engagement means is central. If you are to create a basis upon which, so if you're thinking about the conclusion of the book or of the special issue, for example, right? Where you can bring together the collection of papers so that they can speak to one another. So clarifying what engagement means or how you've thought about it has to be something that should be part of it. And if there are going to be exceptions to that interpretation, those exceptions should still speak to, they can be exceptions, but they still have to speak to that particular definition or interpretation. That engagement, that debate. I guess my question, Uche, was, and you never got back to me, when I was asking about impact, has to do with, it's a methodological question. So you said tracking and finding. You still didn't answer the question, right? When you say impact from a social scientist perspective, which is quite different from legal scholars' perspective.
No, that's public health perspective. The tracking of living is public health.
Yeah, no, I'm fine, public health. But the question is, the question when you talk about impact assessment, you're talking about the relationship between an independent variable and a dependent variable. You're assuming a causality, right? So what I was trying to get you to think about was whether what you were talking about was actually impact, or what you're actually talking about is about output. There's a distinction between output, outcome, and impact, right? And those three things are not the same, right? So,
I like that.
Yeah. So.
I like this playing with distinctions and figuring out what they mean. I think I was asking about what you mean by outcome.
Yeah. So so in that sense, I think you need to. Because claims about the benefits or the limitations with the law can be addressed without engaging with questions around impact and outcome, right? But when you do go that direction, I'm just saying be cognizant of the fact that those particular concepts have specific meaning, right? And they require you to demonstrate a certain kind of relationship, and they require a certain kind of methodology, right? So one has to kind of like, I think in your clarification too, in terms of the benefits of the engagement, part of the, for me, from the little I've heard is one has to clarify, there has to be some speaking to what you mean by impact, or in this case, benefits, or whatever it is that you're talking about,
impact
right?
is not going to feature that heavily at this stage because it's conceptual. It's basically looking at the literature review and research agenda. So I assume that people haven't done empirical work to be able to kind of connect the dots from input, output, outcomes, and impact. I assume that. Maybe some people have, right? So I think at this stage, I think that comes, if we get the grant and do the actual work, then we can do that in a sort of thorough and rigorous way, right? So I assume that. I don't think anybody has to show impact, except, of course, you're relying on secondary studies that have shown impact. That's possible, right? Yeah, so you're not doing the work yourself, but you're just kind of in literature review or whatever. You are saying that impact has been shown by Demudia, Johan and Co. I don't know why I'm putting the two of you together in that co-authored piece, but whatever, right? Any other comment? Okay, I think this is a convenient time to call what has been a wonderful conversation to a close. I don't know about you guys. All that matters is that I enjoyed it, you know, and I sure did, you know. Thank you so much. Dinner will soon be served. We hear they're on their way. And this is not, the caterers are not Nigerian. Because when a Nigerian says, I'm on my way, it means they're just entering the shower. So, but the caterers are Canadians. Thank God. You know, so they'll soon be on their way. And dinner will be in this place. But, so we'll have a health break. Ease yourself, do whatever you have to eat fully, you know, to create space for the food. Okay? All right, thank you so much. Give yourselves a round of applause.